Welcome to Property Law 101. I created this series, Sara Bronin, to help you understand some fundamental questions about property and property law. We have covered 4 questions in the series, and today we are talking about the third, which is using property. And our focus is solar rights. To follow along with this topic, please visit SSRN and download my paper on solar rights and the companion piece, Modern Lights. And you can see a much more extended version of what I'm talking about today. As I say in those pieces, the right to access and harness the rays of the sun, solar rights, are extremely valuable. They have significant economic consequences and, in my opinion, dictate the viability of the entire solar energy industry, at least outside of rural areas. In the United States, attempts to assign or allocate solar rights have, in my opinion, fallen short. There is a lack of coherent legal framework in property law about solar rights. So my point today is for me to talk about what we have so far. And to that, I would argue we have 3 primary methods of allocating solar rights. First, express agreements between property owners or between co-owners or subsequent owners. Second, governmental allocations. And third, court assignments. So first, express easements. So these can come in the form of express agreements, rather. These can come in the form of express easements, covenants, or tenancy arrangements, leaseholds. Again, these involve 2 or more entities agreeing to a specific assignment of solar rights. Other videos in this series cover easements, covenants, and leaseholds and provide important context for understanding what these are. But for here, what we'll say is what they have in common is that they involve bargaining and may be somewhat efficient ways to get property owners to get to their results rather quickly. Unfortunately, express agreements can often involve high transaction costs because you are bargaining one-on-one, usually with lawyers. You might also have to conduct title searches. You might have to do rounds of negotiation. And that is only the case if the parties decide to negotiate in the first place. It's not necessarily the case that parties will come to an express agreement. So one property owner may say, you'll never get an access over my property. At least I won't agree to it. So a second way to identify solar rights is through governmental allocations. And so for that, there are 2 big types of government allocations of solar rights. That is solar permitting or zoning decisions. And what these both have in common is that they are decisions that are made through public bodies pursuant to particular rules. A zoning ordinance might, for example, lay out in advance how property owners might be able to develop solar energy and might constrain neighbors in blocking solar panels. A process for property owners to petition for a solar permit might similarly provide rules for property owners to go through the process and apply. Governmental allocations of solar rights might be preferable to some property owners who like to see the rules in advance. On the other hand, as we know through our study of zoning discussed in another video, these decisions may or may not actually be predictable. So third category of a potential solar rights allocation are court assignments of rights. So in my opinion, these are probably the least efficient in terms of time and cost because you have to go through the judicial process. Courts have not seen a whole lot of cases involving solar rights. And when they do, they fall into the categories of nuisance arguments, prescriptive easement arguments, or implied easement arguments. And again, each of those is covered by other videos in this series. When you think about the prospect of going to court as a property owner, it might be pretty daunting given the cost and given the fact that you may have to go to court to enjoin your neighboring owner from shading a solar collector that does not even yet exist. So the question is whether you really want to make that investment. I argue in my papers back in 2009 that government has not been very efficient, or private parties have not been very efficient in governing and setting forth solar rights. Today, it does not seem like that much has changed, unfortunately. So I leave it to you to consider whether in your careers you will think about this topic of solar rights, which can be realized through many different kinds of property law regimes, and which is probably a significant barrier to the proliferation of renewable energy that we know we need for our communities and our country to help address the challenge of climate change. So I'm going to leave it there. I look forward to connecting with you on Twitter or through my mailing list, and I look forward to seeing you next time. Thank you.